She borrowed $50,000 from her childhood friend, then refused to pay. A handshake and a half-century friendship, and it only took one unpaid invoice to burn it all down. For 31 years, the landlord and the venue owner had been more than business associates. They had grown up 3 houses apart on the same street in a small coastal town, attended the same church, and watched each other's children take their first steps. When the venue owner decided to expand her family-owned wedding venue, a converted Victorian estate she had inherited from her grandmother, the landlord didn't hesitate. In March of a recent spring, he wrote her a personal check for $50,000. No bank, no broker, just trust built over 3 decades and what both parties would later describe, in court very differently. That difference would cost them everything. The landlord filed suit in civil court seeking the full $50,000, plus 8% annual interest and legal fees, bringing the total claim to $61,400. His position was unambiguous. The money was a loan to be repaid within 18 months, the terms of which were outlined in a written agreement he claimed they had both signed the same afternoon the check was handed over. The agreement, he testified, had been stored in a fireproof lockbox in his home office. When he went to retrieve it before filing suit, it was gone. From the stand, the landlord's voice was measured but strained. He described driving to the estate himself, handing the venue owner a check and a 2-page document, watching her sign it and leaving with his copy tucked in a manila folder. He was 63 years old, a man who had managed rental properties for decades. He understood paperwork. He had never, he said, given anyone $50,000 as a gift. Not once in his life. The venue owner told a different story entirely. She sat composed and direct, dressed in the kind of understated elegance that matched the estate she had spent 30 years cultivating. She testified that the money had been given freely. A gift, she said, from a man who had told her he believed in her dream and wanted to see the estate thrive. She produced photographs from the venue's grand reopening the following autumn, where the landlord stood smiling in the garden, toasting with champagne alongside her family. She asked the court a simple question: does a creditor attend the party thrown with his loan money? Her attorney pressed harder. If a signed loan agreement existed, where was the landlord's copy? Why had no payment schedule been established? Why had 18 months passed without a single written demand for repayment? The landlord had no clean answers, only insistence. And insistence, as his own attorney knew, was not evidence. By the 3rd day of testimony, the case had settled into a familiar pattern, his word against hers. 30 years of friendship dissolving in fluorescent courtroom light, each side doing what people do when money is involved, remembering events in the most favorable possible way. Then the venue owner's bookkeeper took the stand. She had worked for the estate for 11 years, and she had not been called by either party. She had come forward on her own. In preparing the venue's financial records for an unrelated audit, she had discovered a scanned document in an archived email folder, a document sent from the venue owner's personal email address to an accountant in the autumn following the check, asking for advice on how to properly record a loan repayment liability on the estate's books. Attached to that email was a partially visible document, 2 pages, the landlord's name, the words repayment terms, a signature line. The venue owner had forgotten it existed. Her accountant had never responded. The judge reviewed the document carefully. It was not the original signed agreement, but it was the venue owner, in her own words, describing the $50,000 as a loan. Before any dispute had arisen, before lawyers had been hired, before friendship had curdled into litigation. It was the most credible kind of evidence, the kind a person creates when they have no reason to lie yet. The judge ruled in favor of the landlord. The venue owner was ordered to repay the full $50,000 with 6% interest calculated from the original loan date, a total judgment of $54,200. Legal fees were split between both parties. The venue owner did not appeal. The landlord did not attend her daughter's wedding the following June, though he had been on the guest list for 2 years. The estate, by most accounts, is still doing well. Somewhere between the champagne toast and the courtroom, 2 people had looked at the same moment and seen completely different things. And here's the question worth sitting with. If that email had never been found, if the bookkeeper had stayed quiet, would justice have been served, or would it simply have been a different verdict?